You are Juan Jose Cerna. Mr. Cerna, you now stand charged yet again with burglary of a motor vehicle. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Hold on to your seats, because what you're about to witness is a Houston judge reaching his absolute breaking point. We got Juan Jose Cerna, a repeat offender with a rap sheet longer than a CVS receipt, caught red-handed breaking into cars at an Old Navy parking lot. But here's where it gets insane. When the judge reads his criminal history, you'll see why this case becomes a masterclass in judicial frustration. And stick around, because we got a bonus case involving ankle monitor tampering that'll make you question the entire bail system. This is raw, unfiltered courtroom justice that you won't believe actually happened. Let's dive in.
On March 20th, 2025, law enforcement officer was dispatched to a burglary of a motor vehicle that occurred in Old Navy parking lot in Harris County, Texas. A law enforcement officer spoke to two witnesses who viewed the incident. The first witness stated that the suspect's motor vehicle pulled up the complaining witness's motor vehicle, and the suspect wearing a camouflage hoodie got out and pulled on a door handle of the complaining witness's motor vehicle, attempting to open it. That set off the alarm of the motor vehicle. And the first witness advised that the suspect got back into a car, drove off to another area of the parking lot, parked and waited for the alarm to stop alerting. The first witness stated that once the alarm stopped making noise, the suspect jumped back over to the complaining witness' motor vehicle, parked, and the suspect in the passenger seat got out and was able to make entry into the complaining witness's motor vehicle. The complaining witness advised that she was walking up to her motor vehicle when she saw a Hispanic male wearing a camouflage jacket sitting in the driver's seat of her motor vehicle. The complaining witness stated that the suspect started walking up, jumped out of her motor vehicle, got into the passenger side of the waiting vehicle with an unreadable plate, and the complaining witness then heard the male tell the driver, "Go, go, go." Another law enforcement officer advised he was patrolling when the gold Tahoe that the suspect was observed in passed him at a high rate of speed. Traffic stop was initiated, and the law enforcement officer was able to send pictures from the witness showing the suspect motor vehicle leaving the location to another law enforcement officer who was able to verify the suspect motor vehicle. After further investigation and search of the suspect, a camo jacket was found in the rear seat and a flat-pointed screwdriver consistent with the tool that would be used to break a lock on the complaining witness's door.
Okay, let's break down what just happened here, because this is textbook amateur hour. These guys literally triggered the car alarm, drove away to wait for it to stop, then came back to the same car. That's like robbing a bank, setting off the alarm, going to get coffee, and then coming back to finish the job. And they had counterfeit plates on their getaway vehicle. But here's the kicker. The victim walked up and caught the man her CR. Can you imagine? You're coming back from shopping at Old Navy, and there's some random dude just chilling in your driver's seat. The audacity is off the charts. And they found the burglary tools in the car, a flathead screwdriver and a camo jacket, matching the witness description. This is what we call in legal terms, caught red-handed with zero plausible deniability.
It was both that were attempting to B&B.
Yes, Your Honor. The defendant is the registered owner of the vehicle, but the motor vehicle was displaying a counterfeit tag that did not come back registered to
So Mr. Cerna is the one that owns the Tahoe?
No, I apologize, Your Honor. Mr. Cerna is the second. It looks like he's second that was in the passenger, that was in the driver's seat whenever the complainant came out. Is not the owner of the vehicle.
Judge, if I may, the complainant or the witness stated that she saw a Hispanic male with a camouflage hoodie. When they were pulled over, there's two people in the vehicle. The camouflage hoodie was not on my client, so I'm saying that there's no probable
They
cause.
have both of them in the car, being car.
The both of them in the car.
That's what, according to you, right?
Yes, Your Honor.
Both individuals.
Were in the car attempting to.
I have the
Because I thought I read that one person wearing a camouflage hoodie was in the car. when
That was the
somebody-
second one. So the first person goes in, gets out, and then that's when the other one goes in. And then at that point, the complaining witness comes up and tells him to take off. Mr. Cerna, let's go through your stuff. Theft of wire or cable, theft, trespass, evading arrest, evading of a motor vehicle, theft, assault of a family member, attempted burglary of a motor vehicle, burglary of a motor vehicle, theft, third, burglary of a motor vehicle, unauthorized use of a motor vehicle, evading arrest in a motor vehicle, burglary of a motor vehicle, assault, possession of marijuana, robbery, felony theft, assault, a prior, now a felony, another felony assault, unauthorized use of a motor vehicle, tampering with a government record, felony theft, unauthorized use of a motor vehicle, and now open, you have unauthorized use of a motor vehicle, felony theft, burglary of a motor vehicle, and possession of a criminal.
Hold up. Did this judge just read out 20-plus charges? This isn't a criminal record. It's a criminal encyclopedia. We've got everything from wire theft to robbery, multiple motor vehicle burglaries, assault on family members, evading arrest multiple times, and even tampering with government records. This guy has basically committed every property crime in the Texas Penal Code. And notice the pattern here. Motor vehicle crimes are his specialty. He's been caught breaking into cars so many times. He probably has a frequent flyer card with the Harris County Jail. The defense attorney tried to argue there's no probable cause because the camo hoodie wasn't on his client when arrested. But come on, when you got this rap sheet and you're caught in a car with counterfeit plates, burglary tools, and the exact jacket witnesses describe, that defense is weaker than gas station coffee. The judge is about to lose it. And honestly, can you blame him?
What on earth do we need to do to keep our county safe? It's a rhetorical question, but I don't know what on earth we need to do to ensure that our county and our cars are safe. You live in Houston, dude. You don't live in Montana or Wyoming. People like their guns and they like their cars. And when you muck with the wrong person, they're going to shoot your ass dead. It happens time after time.
This is the moment where keeping it real goes right. This judge just delivered the most brutally honest warning I've ever heard in courtroom. He's basically saying, look, you keep breaking into cars in Texas, and someone's going to exercise their Second Amendment rights on you. And he's not wrong. Texas has some of the strongest self-defense laws in the country. The Castle Doctrine extends to vehicles here, meaning if you're caught breaking into someone's car, they can legally use deadly force to stop you. The judge isn't threatening him. He's giving him a reality check that the streets might deliver justice before the courts do. This is a judge who's seen too many cases end in tragedy, and he's trying to save this defendant from himself. When a judge tells you it's either dead or 50 years, that's not hyperbole. That's statistical probability based on this guy's trajectory. The real question is, will Cerna listen or is he too far gone?
Judge, he's due in felony court tomorrow for his felonies. His bond is currently set at $10,000 for this misdemeanor. Can we reset till Friday to see what happens in felony? I'm asking the court to not revoke his bond. His bond is set at $10,000. I'm asking the court to just keep it in place.
So there's nothing for me to revoke because he has not made bond on
In
the
felony, correct.
You're now being held at no bond on at least 2 of the felony cases that I see. If I don't know if you're going to get out, but if you do, I'm ordering you to have home confinement. I don't want you out at all because you scare me, Mr. Cerna. You really do. You're not going to be in possession of weapons. On your other ankle, I'm going to put a SCRAM monitor so I know that you're not consuming alcohol. I don't want you using any dope. And let me be frank. If I find that you break any of these conditions on your bond, I'm going to make your bond so high you'll have teeth popping out. Do you understand? Who got the co-defendant? Do we have the co-defendant? No contact with the co-defendant, please, Felicia.
Still loading on our apologize. We have to.
Say it again. You ever had a job before? A full-time job?
Yeah.
That's probably a good idea. When you have too much time on your hands, you become self-destructive. So with this, it's just a matter of time, dude. It's either dead or 50 years, man. Really? Life's too short to live in a 6x9 box for the next 50 years.
Let's talk about these bond conditions because his judge just created the legal equivalent of house arrest on steroids. Home confinement, SCRAM alcohol monitoring on one ankle, GPS on the other. This guy's gonna have more hardware on his legs than a Best Buy. The judge literally said, "You scare me." And when a judge who's seen thousands of criminals says that to your face, you know you've reached a special level concerning. The teeth popping out comment about raising the bond, that's judge speak for, "I'll set it so high, your grandchildren will still be paying it off." And that philosophical moment at the end, life's too short to live in a 6x9 box for 50 years. That's not just legal advice, that's life advice. The judge is practically begging this guy to get his act together. But based on that rap sheet, what do you think the odds are? Let us know in the comments. Is this tough love going to work? Or is Cerna beyond redemption?
All right.
So I have talked to pretrial in regards to the violations as to tampering with the SCRAM.
You need a translator anyway, right?
I guess
Vicky
so.
Ramirez?
Yes. So pretrial doesn't know exactly what was tampered with. He does work in construction. He wears socks. He does suffer from this condition called neuropathy, where he has to put like this cream on here. He says that SCRAM actually has been causing him a lot of pain on his legs. So sometimes he shifts it to put the lotion or moves it. But since it was in the morning, he said it was probably like when he was at work with the boots. But there was no DAC, no alcohol, nothing. It was just
Because a
tampering.
lot of times the way they do it, they tamper with it so that alcohol can't be detected. They'll put something in between the leg and the monitor this is Enrique Ramirez.
This was,
A lot of times they'll say the tamper was from midnight to like 6 a.m. so that we know that there was something in between the leg or they've done something for that length of time. I don't know.
See the first one.
And it says
began
alcohol was
at
detected.
On March 1st at 4:32 a.m., returned to baseline at 2:40 p.m. That tamper was 10 hours and 8 minutes.
Now we got a completely different defendant with a classic ankle monitor excuse. Enrique Ramirez claims he has neuropathy and needs to adjust his SCRAM monitor for medical cream. But here's the thing, a 10-hour tampering event? That's not applying lotion. That's attempting to beat the system. The prosecution knows exactly what this looks like. Defendants commonly place barriers between their skin and the monitor to prevent alcohol detection. They think they're slick doing it overnight when they assume nobody's watching the data. But these monitors are sophisticated. They detect any break in skin contact. The defense attorneys try and play the medical sympathy card. But when you got a 10-hour gap in monitoring and alcohol detected during the first event, that excuse holds less water than a broken dam. The real tell? These tampering events happen at suspicious times. Early morning hours when someone might be drinking thinking they won't get caught. The judge is not buying it, and neither should we.
Come up, Mr. Ramirez.
I don't see the second one. I see the one on the first.
I don't know what to tell you, Ms. Solis, but
oh, I mean, pretrial doesn't have knowledge as far as like what was the tampering. I mean,
they can't. It's impossible.
I know that, Judge.
All we know is that the device was not detecting his skin for a certain period of time. And at the same time, alcohol is detected. So let's do this. I need to get a translate here so I can properly translate and let him know what I'm going to. Oh, Blasa.
Yes.
Can I borrow you for a second, please? No, I just need you to help me translate.
Oh, okay.
Mr. Ramirez, you were instructed not to tamper or remove the device. We have 2 tamper events here, where on March 1st at 6:33 a.m. and the second one on March 10th of 2025 at 11 a.m. Alcohol was detected on the first event. Alcohol was not detected during the second tamper event. That's what I have. We need to do something with this case. It's 207 days old and he's now tampering with the device. So
I know, Judge. I mean, we're ready for plea today, but
you're tampering with the device and you're consuming alcohol. Told you not to. Let's do this. I'll send it for a drug and alcohol test right now and he'll.
Judge, yeah, because he has no status. If he goes in custody, he will get a nice hold.
I have admonished you ad nauseum not to violate conditions, because if you go to jail, there will be serious consequences. And we now have tamper events and a positive alcohol rating. I am now going to send you for an alcohol and drug test right now. I want to know what, if anything, that you will test positive and you're to come right back.
Because he does say, he does use the creams on his arms and hands, so it doesn't have a BAC level or anything in regards to the SCRAM, so.
Advised of.
I understand, Judge, I understand.
All I know is that alcohol was detected and he's tampering with the device.
Judge, all right, well, so I'll step out and then, thank you.
What we just witnessed here is the harsh reality of our criminal justice system. Repeat offenders pushing judges to their breaking points, and defendants trying to game the very systems designed to give them a second chance. Juan Jose Cerna's case shows us what happens when someone accumulates over 20 criminal charges and still doesn't learn. The judge's warning about getting shot wasn't fear-mongering. It was a desperate attempt to save a life spiraling toward inevitable tragedy. Meanwhile, Ramirez's ankle monitor case demonstrates how defendants try to manipulate bond conditions, thinking they're outsmarting technology that's specifically designed to catch cheaters. The 207-day-old case with multiple violations shows a pattern of disrespect for the court's authority. Both cases highlight a critical question. At what point does the system stop giving chances? These judges are trying to balance public safety with rehabilitation, but when defendants repeatedly violate trust, eventually that balance tips toward incarceration. If this breakdown of real courtroom drama shocked you, smash that like button, drop a comment telling us which case was more outrageous, and subscribe with notifications on so you never miss our next jaw-dropping courtroom breakdown. What would you do if you were the judge? Let us know below.